Preet Gill.
Thank you, Mrs. Lang. The Withdrawal Bill intends to bring existing EU legislation into UK law, and in doing so, we must ensure that the fundamental rights of children are not diluted as a result of this process. With our exit from the EU, the UK plans to no longer be party to the EU Charter of Fundamental Rights and will not automatically benefit from the children's rights protections that exist within the EU legal framework. For example, the Treaty of Lisbon introduced an objective for the EU to promote the protection of the rights of the children, and the Charter of Fundamental Rights guarantees the protection of rights of the child by EU institutions as well as by EU countries when they implement EU law. The best way to ensure that these rights are maintained after Brexit is to enshrine the UN Convention on the Rights of the Child into UK law. And whilst the UK is a signatory of the UN Convention, it is not enshrined in domestic law. The Withdrawal Bill removes from UK law the European Charter of Fundamental Rights and proposes that fundamental rights and principles are considered in place of the Charter when implementing case law or legislation. That refers directly to it after exit day. The Children's Society have rightly raised their concerns that there is no further information on what these fundamental rights would be, or any clarity as to whether the development of children's rights envisioned in EU law would be considered to be fundamental rights and principles. That's why, in the absence of any clear definition, further integration of the UN Convention of the Rights of the Child into UK law would provide the framework for these fundamental rights for children. Thank you.